Hello, everyone. Today we'll be talking about jury selection, and then the other lecture for this module is about jury decisions and deliberations. So this week is all about juries and how psychologists can give insight into how they might function, and in so doing help attorneys make some decisions about who might be on the jury. And if you're not familiar with the legal system, you may be sort of confused as to why and how that could be a thing, but we're going to go over that today. So jurors come from a couple different places depending on your jurisdiction, but most likely they tend to be from the selection pool of registered voters, and then they are randomly selected from that. And then you get a jury pool from that, and then the jury is established from there. And then just a reminder to complete your assignment prior to going on in this lecture if you haven't done so already. So next thing we're going to talk about is voir dire, which is the fancy name for jury selection. So in theory, jury selection must neither systematically eliminate nor underrepresent any way subgroups of the population. And to encourage that representativeness, the U.S. Supreme Court has had cases such as Strouder v. West Virginia in 1880 that have forbidden systematic or intentional exclusion of religious, racial, and other what they call cognizable groups from jury panel. So cognizable groups are those that, because of some shared characteristics, might also hold unique perspectives on specific issues. So before this case, veneers or jury pools were largely middle-aged, well-educated Caucasian males. Congress and the Supreme Court require that the jury pool be a representative cross-section of that community. The resulting juries would be more heterogeneous, and the idea is that those types of juries, those sort of mixed juries, are expected to be better fact finders and problem solvers. It's a theory. Representativeness at least gives the appearance of fairness and legitimacy of a trial and of the resulting verdict. And whether or not that ever actually happens, doesn't happen, is sort of for debate. So the first thing you do when you're doing jury selection is you draw a panel of prospective jurors called the veneer. You've heard me just use this term, from a large list. And that list is usually based on voter registration and also lists of licensed drivers. The Jury Selection and Service Act of 1968 required that voter registration lists be used as the primary source for jury pool selection, but such lists risk underrepresenting certain segments of the community. So think about the controversies that have surrounded ID laws, for example. To increase representativeness, then states will use other sources, such as lists of licensed drivers, persons receiving public assistance, and unemployment lists. So if they have a list, they'll use it, sort of. You can also make it so historically underrepresented groups receive a larger number of jury summons, making it more likely that they will serve. Once a pool of potential jurors has been drawn, each individual in the pool receives a questionnaire to assess his or her qualifications and ability to serve. Some are excluded by law, so those who are considered mentally incompetent, for example, and actually those who are blind due to the visual nature of a lot of the evidence that is often presented. From those eligible for jury service who actually return the questionnaire, members of the veneer are randomly selected and then summoned to appear for jury service. Many qualified jurors will ignore the jury's duty summons, even though that actually violates the law. Exclusions, non-responses, and exemptions can distort the representativeness of juries as a result. And really interestingly, until recently, members of some occupations were automatically exempted from jury service. So, for example, New York used to exempt physicians, firefighters, veterinarians, phone operators, and embalmers. And this goes back to the importance of each of these roles in small towns. So if the one physician is gone for several days on a jury, could be problematic. However, most states have now eliminated all exemptions. So once the veneer is actually been drawn, actually been selected, then a process called voir dire is employed to question and select the eventual jurors. Voir dire means to speak the truth in French. So the idea here is that you're going to question the prospective jurors and they will speak their truth about these questions. So jurors are expected to respond truthfully to these inquiries. They might be about their opinions. And then it's a process to really try to filter out bias. You want objective jurors. You want to weigh evidence fairly and accurately. So an example I often give here is that my mother was called for jury duty. It was a mugging case. They asked if anyone had ever been mugged, and she had. And they asked her if she thought she could be objective in the case, sort of related to her personal experience. And she said, you know what, honestly, I don't think I could. And they dismissed her. I said, all right, you're not going to be on this case. However, really in jury selection, attorneys are often choosing jurors based on their own agendas. You're looking for jurors that you think will either convict or acquit, depending on which side you're on. And each side has an equal chance to choose jurors in favor of their opinion. Attorneys also get the chance to kind of suck up to jurors. It's their first interaction. They can start sort of ingratiating themselves with those prospective members of the jury. So this is now a very complex process. There are actually three sides. There are the two lawyers and then the judge. So they're all there and they all have conflicting goals. The most limited form of voir dire involves a small number of questions asked by the judge in yes or no format. It features group rather than individual questioning of prospective jurors. Yes or no questions actually offer very little insight into jurors' actual beliefs and attitudes. And some jurors will not disclose important information because of privacy concerns, embarrassment, a desire to provide socially desirable responses, or a failure to recognize their own biases. There are times we just don't recognize them in ourselves. So the judge will decide how voir dire is actually conducted. The judge has the ultimate power here. And in federal courts, there's a brief voir dire where the judge asks general questions. The judge is more active. They don't ask questions about opinions or beliefs, just facts. Like, do you know anyone in this case? Clearly, if you know someone, you have to be dismissed. You can't have that bias. How much exposure have you had to media coverage, for example? There can also be what's called extended voir dire, where both the judge and attorneys ask open-ended questions that require elaboration and cover a wide variety of topics. In this case, jurors are questioned individually, which takes away some of those concerns about saying things in groups we talked about. So there are several advantages here in uncovering biases. They encourage jurors to talk more about their feelings and experiences. Individual questioning can result in disclosures they might not otherwise offer as well. Now, typical voir dire is, of course, different than what we've actually talked about. Typical voir dire procedures involve a compromise between the limited and extended versions. So both the attorney and the judge pose questions to the group of prospective jurors, and then they ask brief follow-up questions to sort of a subset of selected individuals. So it's a compromise. In that case, attorneys will be the ones who do question the jurors. So they can dismiss jurors via what are called challenges, And there's a couple different types of challenges. One is a challenge for cause. So a challenge for cause is there's a reason to dismiss them. So their attitude about the crime, they know the person in the trial, they have a certain opinion about potential punishment, like the death penalty in those types of cases. The idea here is that the individual is so biased that they could not render a fair verdict, or maybe even is unwilling to follow the law in charging this particular case. And there's an unlimited number of challenge for causes for each side. And then there's the peremptory challenges, and these don't allow for debate or argument. You don't need a reason to do these. You can just say, nope. Usually attorneys use these when this person will favor the other side, so they get rid of them. And there's a limited number here allowed. And you get more of these the more serious the case, and the defense always gets more. These types of challenges have multiple purposes. They allow attorneys to challenge potential jurors who they believe will not be sympathetic for whatever reason to their client. They allow those in a lawsuit to play a role in selecting the people who will decide the outcome, and thus they may be more satisfied in that outcome. And then they also allow the attorney to begin to, again, indoctrinate, ingratiate prospective jurors, and influence those who will ultimately make up the jury. As a result of Baston v. Kentucky in 1986, when a defense attorney believes that the prosecution's peremptory challenge was motivated by racial factors, he or she can initiate a so-called Baston challenge. And the judge then asks the prosecutor for an explanation for that challenge. The prosecutor typically advances a race-neutral explanation for that challenge, and then the judge determines whether or not that explanation is actually genuine. In 1994, in JEB v. Alabama, ex rel. TB, the Supreme Court extended the logic of Baston to challenges based on gender as well. So not just race, but gender. So in summary, these challenges may not be based solely on a juror's race or gender. Now, in traditional jury selection, the stereotypes, beliefs, personality, attitudes are judged by the lawyer. So what criteria used will depend on the incident and will also depend on who the defendant is. Problem here is what's called illusory correlation, and that is our beliefs that things are related that might not actually be related. So believing that things are linked with no evidence to back it up. Illusory correlations are usually rigidly held and really hard to change. So definitely some issues here. Trial lawyers often apply their implicit personality theories to jury selection. And an implicit personality theory is a person's organized network of preconceptions about how certain attributes are related to one another and to behavior. And these, not surprisingly, can be mistaken. Attorneys also sometimes use strategies that rely on the similarity leniency hypothesis, and this is the assumption that jurors who are demographically or socially similar to the litigant will be predisposed to favor that litigant. This may or may not be true. A competing theory is the black sheep effect. People may sometimes strongly sanction those fellow members who reflect negatively on and embarrass the in-group. So this person has committed a crime that reflects poorly on our group. When the evidence against the defendant is weak or ambiguous, jurors tend to favor defendants who are like them in some way. So that's similarity and leniency hypothesis. But when the defendant's culpability is very clear, jurors are harsher on the defendants with whom they share those demographic features, and that is that black sheep effect. And these effects seem to apply only to individual jurors' demographic closeness to the defendant and not entire juries. There's also what's called the first 12 called rule, and some attorneys will use this. Attorneys will just accept the first prospects called to the jury box, sometimes deliberately drawing jurors' attention to their willingness to believe that anyone can be fair and be trusted to describe or discuss or decide on the case objectively, right? Or correctly, as the attorney would see it. In terms of demographic characteristics of the jurors themselves, trial attorneys must make informed guesses about which prospective jurors will actually be more favorable to their side. So to do so, they will rely on these demographic features because they're easily observable, so something like gender. However, juror demographic characteristics are actually only very weakly related to juror voting decisions, and they may vary depending on the type of case. So some sample findings here. In a study of attorney effectiveness, experienced trial attorneys were observed to use juror selection strategies that were not different than or any better than inexperienced college and law students who were asked to evaluate the same mock juries. Attorneys did no better than chance in detecting jurors who were actually biased against them. Attorneys don't actually predict any better than chance. They do a little bit better on murder trials. So for that reason, especially high-powered firms, well-off attorneys, have started to rely more on what's called scientific jury selection. So a psychologist or another social scientist in this case helps lawyers identify jurors that will help their case. Consultation is much more often for the defense than the prosecution in these cases. And what are the methods we use as psychologists to actually help with this? So there's a community survey where you measure the persuasiveness of arguments and evidence to be presented. You can also ask about perceptions of case characteristics, the litigants, the trial-related issues. You think about backgrounds and activities, and you developed demographically based profiles of individuals who are most or least responsive to the case themes. There's the pre-trial survey, which are given to individuals summoned to the courthouse for trial. And this will not include questions regarding evidence persuasiveness. There are mock juries, where you examine how different types of individuals respond to different trial situations and approaches to information presentation. So you might have the attorney practice several variations of their opening and closing statements and see which is most persuasive. Focus groups are similar to mock juries, but with less structure. And then many jury consultants provide services in realms other than jury selection. So for example, consultants conduct public opinion surveys, focus groups, the mock trials, and analyze how different jurors form a narrative that summarizes the evidence. This allows consultants to derive central themes, which can be used to organize the evidence to support the attorney's desired interpretation of the facts. Now, more research is needed on scientific jury selection. It really depends on the case to a large extent. It works better on court-martial cases, drug cases. The effectiveness of a scientific jury selection really depends on a number of variables, including how many of those challenges are allowed, the extent to which questions delve into matters beyond superficial demographic details of the prospective panel members, whether attorneys act on the guidance of the consultant. You could do the best job in the world as a psychological consultant, but then the lawyer ignores everything you suggested because of their own gut, right? And perhaps most importantly, the extent to which jurors' attitudes and beliefs will actually determine the outcome of the case. So there are two methodologies that are often used here. Demographic characteristics is the panel representative of the community, and then juror characteristics related to the outcome that the attorneys want. So you need to actually relate the characteristics to the outcome. You can ask the person how they would vote if they were on a jury in a community survey. The problem, however, is that they might say one thing on the survey, but once they're on the jury, they might actually do something differently because they haven't actually heard the evidence in the case yet. To fix this, you can try to present the facts in an unbiased way during the phone survey or mock trial to get as much as you can. As we've mentioned previously, demographics are really limited with a weak relationship and seem to be pretty case specific here. They can be helpful in federal cases when you don't have much else to go on. So people who are from higher socioeconomic status, those are more well off financially, are more likely to convict. When it comes to race, we can see they can either be sympathetic, or if they are of higher socioeconomic status, sort of more well off of the same race, they may be more likely to convict because of that black sheep effect. They believe that that person reflects poorly on the community. Interestingly, one thing that's come out of research is that African American jurors are more likely to support not guilty by reason of insanity. Gender, so in cases related to women and kids, women tend to rule in favor of women. So if you're looking at rapists, child sexual abuse, sexual harassment, you want to kind of take that into account. Women are also more likely to acquit battered women, so women who have been abused, who then kill their husbands. Now, in terms of personality characteristics, there's a couple here. Authoritarianism predicts conviction and also predicts harsher sentences. So authoritarianism is that anyone who's perceived as having less authority than you is judged very harshly. But people who have more authority than you, sort of the opposite, they get a lot of leeway. So people who are authoritarian may want to please the judge and be really influenced by the judge's nonverbals. Then there's locus of control, and this is internal. You feel responsible for what happens to you. And they are more likely to believe that others are responsible for their own opinions. So there was an article on scientific jury selection in 2011 written by Lieberman called Still Murky After 30 Years. It was in Current Directions in Psychological Science. And it talked about this. And it said attorneys are using trial consultants for almost all major litigation. So this is being used quite frequently. But it's still somewhat unclear how effective it is. So consultants themselves report high success rates. I mean, of course they do, right? They want to get more business. But it costs a lot to hire a consultant. So it's used in cases where premier attorneys are also used, and they can afford skilled expert witnesses. So it's unclear, like, is it actually the scientific jury selection that's helping, or is it all these other factors that you have the best attorneys, the best expert witnesses? And in terms of demographic factors, these actually tend to account for less than 2% of verdict variance when actually examined independently. If you put all the demographics together, they account for less than 5% of the verdict variance. They're inconsistent and they're really context dependent, as we keep saying. So for example, gender is unreliable, but again, clearer in cases where there's sexual violence involved. There might be a legal personality or legal attitudes. So this might have greater predictive accuracy when specific measures of legal attitudes relevant to trials at hand are used. So for example, attitudes towards psychiatrists in insanity cases. Even with all these factors, what we can predict remains pretty low. And little research actually examines the effectiveness of scientific jury selection. Research out there does suggest over 70% accuracy rate, but it's unclear how credible these results are. They're often highly artificial and not directly comparing individuals using the scientific jury selection versus the traditional method. So it is suggested that SJS may be most beneficial when the evidence is sort of equivocal and there might be a slight advantage that could impact the outcome of the case. So really it's like where you could tip them. And then there's evidence strength. This is a much better predictor of jury verdict than actual jury characteristics. So juror characteristics are, again, about 2 to 5% of the variance. Evidence strength is 34, a third of the variance in decisions. So in cases where the evidence is really strong, scientific jury selection should be a weak influence. But one of the things that happens is these cases actually rarely go to trial. People will plea bargain, things along those lines. When the evidence is relatively balanced, then those small increases in predictive ability gained by scientific jury selection could actually be advantageous. Now, what are some of the ethical issues in jury selection? Critics have condemned these techniques as quote-unquote jury rigging, techniques that undermine public confidence in the jury system and give wealthy litigants an unfair advantage over poor average income citizens who can't afford to have their attorney hire a consultant. However, many believe that because litigants are expected to present their version of the case as zealously as possible, they should be able to use every legal means available to sway the jury to reach a favorable decision. Now, the last thing we're going to talk about in this lecture is the judges versus jury's decisions. Defendants in criminal trials ordinarily have a jury trial, but if the prosecutor consents, they can choose to have a judge decide in what's called a bench trial. Citizens believe a jury decision offers more procedural fairness, greater thoroughness, better representation of the community, fewer personal biases affecting decisions than a decision by judge. And do judges and juries actually agree with each other? Well, Calvin and Ziesel in 1966 asked judges questions about recent jury trials. So they asked, what was the verdict that the jury came to, and did the judge agree? In criminal and civil trials, judges responded that their verdict would have been the same as the jury's actual verdict in about 75% of the cases. Only 19.5% of the criminal cases did the judge say, the jury said that this person was guilty, and I would have said not guilty, or vice versa. In most of the discrepant decisions, the jury was actually more lenient than the judge would have been. Now, in terms of what determines those discrepancies, a few of the discrepancies apparently resulted from facts that one party knew but the other one did not. In some trials, the jury was swayed by the apparent superiority of one lawyer. And about half of the disagreements involve what are called jury sentiments. So feeling expressed by the judge that the jury verdict was determined by factors beyond the evidence and the law. So there have been some critiques of this Calvin and Ziesel study. The judges were permitted to choose which trial or trials they reported, so they may have only reported on the ones they wanted to talk about, essentially. And they sent the survey to 3,500 judges, and only 555 of those actually responded. So you're not necessarily getting a representative sample there. In addition, juries have changed in many ways since the study was conducted back in 1966. And then we only have the judge's attribution of what the jurors' feelings and sentiments were. We don't actually know what the juries were thinking in those cases. Now, some new data on judge and jury differences comes from researchers at the National Center for State Courts. This was published in 2005. And they collected data from jurors, judges, and attorneys in more than 350 trials. And they found that the rate of jury and judge agreement was 70%. And when there was disagreement, the juries were more lenient, which again is very similar to what we just talked about in the Calvin and Ziesel study. Jurors do tend to be more lenient than judges when it comes to determining guilt, but they can be actually more harsh in deciding sentencing. So why? Why are they more harsh when deciding sentencing? Well, one explanation is that jury trials are very expensive, and judges want to encourage defendants to plead guilty and avoid those costs. Thus, judges may deliberately choose more lenient sentences as an incentive to encourage plea bargaining. Another study analyzed data from nearly 9,000 civil trials, and the primary finding was that judges and juries did not differ substantially in these cases. They awarded punitive damages for about the same size, And although the range of jury awards was somewhat greater than the judicial awards. Now, what about the psychology of trial judging? So this is from a study by Vidmar in 2011, also in Current Directions in Psychological Science. Judges are subject to influence by personality, attitudes, past experiences of themselves, much less the other people in the room. So in terms of training and legal precedent, lawyers are taught to look at the facts and reason by analogy. So you apply facts and you place them in categories. It's kind of similar to scientific disciplines, to be honest. And judges generally begin as lawyers. However, legal decision-making also has heavy deference to precedent. So if the judge strays too far from the precedent, then the case will be appealed and the ruling overturned. And the judges are also dependent on the evidence presented. And so that's going to affect the quality of their decision. As we mentioned previously, in some European countries, the judge has the investigative powers, and that can kind of negate some of this. Also, the judge's work is embedded in bureaucracy, so there are some constraints to what they can do. Legal training does not actually seem to insulate judges from common cognitive errors. So, for example, in one study, when judges were presented with inadmissible evidence that should be disregarded, despite their legal training, judges reacted in a way that was pretty similar to laypersons. They could not disregard these inadmissible facts once they had heard them. Another showed judges as prone to stereotypes as anybody else. And in terms of sentencing decisions, there are disparities based on race, ethnicity, and gender. There tend to be longer sentences for Hispanics and African Americans. And some studies suggest that these might be influenced by courtroom behaviors, but there's also disparity in how those folks are treated by probation officers and often the legal representation they are able to get. All right, I hope that this was illuminating about how juries are selected. Next up, we're going to talk about how juries actually make their decisions once they have heard the case.